Okay, so we're here to talk this week about important cases that have affected asbestos and mesothelioma litigation over the course of the last week. And there are 4 cases that are particularly important that I want to talk about. The first case is the Graham Yates case, and it involves Ford Motor Company. In this case, there were multiple sources of exposure, and the plaintiff was exposed as a seaman doing home repairs and brake work. And his work on Ford cars involved his work on his own cars, on replacement brakes when he was in a Ford dealership. And he was also exposed to brakes made by Bendix, taking the brakes out of boxes and being in the area where mechanics were using the brakes and helping the mechanics. And the case was at the pre-trial stage and very, very hotly contested. It involved the typical battle over experts. There were experts submitted on causation, that is, did the product or could the product cause disease, something known as state of the art, which means what was known and knowable to the defendants when they sold or manufactured the product, and then some very specific kinds of defenses that are asserted in these cases. And one of the primary battles in this case, and what the judge had to rule upon, was, were the defendants on notice of the potential dangers of asbestos? The defendants said they weren't. They didn't have specific knowledge, and the plaintiff said, oh yes, they did, and this is how. The plaintiffs contended that the medical literature dating back to the early 1930s demonstrated that there was clear notice to anybody who looked that there was danger related to asbestos exposure. And in particular, they said for brake dust exposure. The defendants said, no, we didn't have that information. The plaintiffs had some crucial pieces of evidence, however, that were in addition to the regular medical literature. The first thing they had is they actually had a deposition of a man who used to work for Ford, an executive named Roslinski, who provided information on what was known or knowable to Ford at the time he was deposed. I think Mr. Roslinski has since deceased, so you can use that deposition in a lawsuit. They then introduced 2 sets of information from trade associations that the defendants were members of, and I think Ford in particular. One was the American Society of Mechanical Engineers, saying, well, you have a lot of mechanical engineers that work for you, and they were a member of the society. And this is the medical literature, the journals that went right to their doorsteps, to their home, to their work. And the other was something known as the Industrial Hygiene Foundation that had been around since the early 1930s. And the purpose of the Industrial Hygiene Foundation was to provide information to industry about dangers in the workplace. So that was one of the purposes. And every month they would send out to companies like Ford and others digests of medical information related to the dangers of asbestos. So the court looked at that and thought that that was extremely important. They also had a major battle over causation. Generally, in an asbestos case, you have to prove that the exposure was a substantial, not the only factor, but a substantial factor in causing the injury. And you could have more than one substantial factor. It's kind of like if you put 3 different colored juices in a glass of water, they all have a responsibility for changing the color of the water. And that's kind of how cancer works. At least that's what the scientists say. So the defendants, Ford and Bendix, they took the position that there just wasn't enough exposure. And there was a legitimate battle over that. And the court decided, no, there was enough exposure. The man had exposure in the shop, in the workplace, at his home, even unpacking the boxes. And then the court looked at the crucial issue. Was there enough notice here? Did the defendants know, or should they have known, of the dangers of asbestos. And the court found, at least at the pretrial stage, for a jury to decide later on, but it had enough evidence to move forward. And it said, the record here demonstrates a genuine issue of material fact. That means something for a jury to look at, as to whether the defendant Ford should have known of the dangers posed by its product, and thus had a duty to warn, given the state of the art, meaning what was known, concerning the dangers of asbestos. And the court goes on to say there is no dispute that asbestos had been identified as a potentially harmful substance by the 1930s. An important case, they fight very hard, and you have to give tremendous credit to the lawyers in this case. Lisa Shirley, I know, is one of them at the firm of Simon Greenstone, who do a great job. And the amount of evidence they put in at a pretrial stage, remember this was not trial, was really significant, and a significant battle. The next important case, and I actually had to read the case 2 times, was a case called Gottschall, and it involved, there were 2 cases I had to read twice, and it involved the issue of a sophisticated user. Under some, not all. If you can prove that the place you sold the product to was so sophisticated that a warning would not have made a difference, you may not be held responsible as a defendant. Well, in this case, the Gottschall case, the exposure took place in the Navy. And it was a very interesting case. This doesn't happen very much, but half the case was filed in the state of California, and the other half of the case was filed in federal court, and it ended up, because of pretrial proceedings and the way the federal courts work, with a handling judge in Pennsylvania. And the judge who handles the cases in Pennsylvania, Rebrano, looked at the law and said, I believe that this case should be dismissed under California law, because the federal court's job is to try to figure out how a state Supreme Court would actually decide the issue. And they said, well, based on these issues, we are going to find that in this case, there was no duty to warn, because the sales went to the Navy, and the Navy was a very sophisticated purchaser. It was knowledgeable about the dangers of asbestos going way back, and therefore the defendant is absolved. The other half of the case was then decided in the California court, and the state court at the trial level actually went along with the federal court. But then when it went to the appellate court, the federal court, the appellate court said in California, well, we think the federal court in Pennsylvania was wrong. So the case actually now lives on, at least part of it, in California. And it's important to note that this case just shows the interplay between what happens in federal and state court, and it matters where you are and who's deciding it, and it also matters what state law applies. So that was a case, and I had to read that one twice too. And then there was another case called the Hayes case in Florida, and it was litigated by a friend of mine, John Ruckteschall, who just did an awesome job. And again, a very difficult case legally, but how this came out, you really have to read the case carefully. And I'm posting all these cases on my website, Mesothelioma Legal Blog. So if you want to read them yourself, you think I got it wrong, but I didn't, you can actually look at it for yourself. But what happened here was that the case again was in Philadelphia, because it was originally ended up in federal court, transferred to Philadelphia. This person had exposure in 2 places. He had exposure on land and on a ship while he served in the Navy. And what happened in the federal court case, when it was in Philadelphia, was that the federal judge who oversees all the cases said, well, in my opinion, the maritime law applies here. And even though you may say that he had exposure on land, I believe that maritime law will apply. And as a result, we have to be governed by the special law of maritime law, which isn't the law of any state, it's a federal law. So what happened then was, after that ruling took place, the MDL judge, the supervising judge, sent it back to Florida for trial to a federal judge in Florida. If you think this is a little complicated, it is to the average person. So it went back to the federal court in Florida. The district judge was a very, very fine judge. And the defendant says, well, wait a second. We know that the judge has ruled that maritime law applies, but we believe that if you look at the law, this plaintiff can get pain and suffering because there are two laws that potentially apply: the Death on High Seas Act and something known as the Jones Act. And the defendant said, well, you could have no pain or suffering. And so that was what the judge had to decide. And the judge said, well, he ruled basically he ruled against the defendant. He said, well, just because you have some exposure on the high seas, that doesn't trump everything else, because all of the exposures combine to cause one injury. Remember, I told you before about the glass with the different colored juices in the water. And then the defendant said, well, even if the Death on High Seas Act doesn't apply, your claim for damages are still limited because under the maritime law, you are a seaman, and seamen aren't entitled to pain and suffering. So the judge then had to look at that law and looked at cases across the country. And again, he ruled in favor of the plaintiff. And he said that, that the plaintiff may not be able to cover economic loss, but his estate, or I'm talking pain and suffering rather, but his estate may cover those damages for his pre-death pain and suffering under the maritime law. So the end result in the complicated case is that in this case, a very good judge decided that this plaintiff could actually recover for pain and suffering despite the arguments that were made by the defendant. So what do these four cases really tell us? They tell us that it is extremely important that you know the courts that you're in, you know the law that applies. Just because it's an asbestos case doesn't mean that every case is the same. Cases are different. The legal rulings govern a lot of what happens. Although the substance is the same, asbestos, the state laws in the various states differ dramatically. And because the state laws differ dramatically, in some cases, not in other cases, you really have to be careful. So in this case, in these cases, these plaintiffs picked excellent law firms who did excellent work and put a tremendous amount of time and money into these cases. I hope this was helpful. If you have any other questions, you want to read this decision or any of these decisions, go to the Mesothelioma legal blog and you can see them for yourself. See you next time. Thank you.